Welcome back. I'm Stacey Delikat. You've been watching live testimony in an Ohio courtroom. This is the case against Shawn Grate. He is charged with murdering two women and violently raping another, abducting all three. Quite a disturbing case. And all morning we have been hearing from one of the chief investigators in this case who responded to the scene, found two decomposing bodies, and the third woman who did survive, who's being called Jane Doe, did encounter her. There has been a very disturbing testimony as we've heard about this house of horrors that police found when they responded to Shawn Grate's home. We are going to have a lot more coming up on this trial. Right now, the judge just announced a 1-hour lunch break, and in just a little while, we're going to recount some of the highlights so far. This is day 2 of testimony. But first, I want to bring in Law and Crime trial analyst Julie Rendelman. Thanks for being here as always, because the other big trial that we were covering here for weeks and weeks and weeks, Grate Tex McIver out of Atlanta. As we know, yesterday, a pretty surprising verdict, the jury acquitting him of murder but finding him guilty of felony murder and aggravated assault. So I know all of our Law and Crime regulars have been pretty shocked by this. I have to hear your reaction.
Shocked is you know, it's funny when as a prosecutor and as a defense attorney, when you're sitting in the courtroom, I think you're incredibly nervous, overwhelmed, sick to your stomach, and I think a lot of people were on Twitter saying that they all felt the same way, that there was such an incredible nervousness. And then when it came in, I have to be honest, I admit to being upset about it. I don't think it's the right verdict.
Let me stop you right there, because let's actually play that verdict so those who weren't watching yesterday or may not have seen it can catch up, and then we'll discuss more.
Juror 20, I would like you please to publish the verdict, which means read the verdict into the record.
On count 1, murder, we find the defendant not guilty. On count 2, felony murder, we find the defendant guilty of felony murder. On count 3, aggravated assault, we find the defendant guilty. On count 4, possession of a firearm during the commission of a felony, we find the defendant guilty. On count 5, influencing a witness, we find the defendant guilty.
Thank you, Juror 20. You can take a seat. Deputy Murphy, if you would please give the verdict form to Mr. Rutter and then to Mr. Harvey.
Okay, that was a replay of the verdict being read in the murder case against Grate Tex McIver. Again, the jury acquitting him on the murder charge, but finding him guilty of felony murder, guilty of aggravated assault, as well as some lesser charges. Tex McIver himself pretty much showed no emotion as that verdict was read. But as you were just saying, Julie, when you were watching this yesterday, you had strong emotions.
I admit that I've been one of those people that have had strong emotions throughout this case. I don't believe in it. I don't see what the jury saw. I'm a little confused by the jury's verdict, because if we analyze it, they came back with basically felony murder, which indicated that he didn't intend to kill his wife. Instead, he intended to injure his wife and killed her as a result, which is completely contrary to what the prosecutor's position has been throughout this trial. So I don't understand how that fits into this. And so, yeah, I'm shocked. And I think that one of the things we're going to be seeing and hearing a lot about is the appeal, because I think there are incredibly strong appealable issues in this case that any defense attorney is going to be pursuing.
Yeah, I mean, I would imagine that is the case, that they're probably already working on their appeal. What we know is that the jury deliberated 5 days, many hours, and they were clearly deadlocked, and they kept coming to the judge, asking questions and saying that they couldn't come to a verdict. But then yesterday morning, a sudden switch after the judge said, you know what, no, I'm ordering you to go back one more time. And next thing we know, they come out and say, here's our verdict.
Right. I mean, they were given an Allen charge, which basically, it's not to intimidate them into going back. It's to basically ask them to be open-minded about other individuals' views and be open to the idea that their view may be wrong, or that they may be open to kind of the idea that they're not accurate in terms of their view of the evidence. You know, he gave the Allen charge, which is the appropriate charge to give when a jury is deadlocked. A lot of people are shocked that they came back so quickly. That's not unusual. Sometimes it's one person that's holding everyone else up. Sometimes it's just a push to, I hate to say it, but to compromise, which is not something we want to hear, but it is sometimes they're sick of deliberating.
These are human beings. They're away from their lives. They can't talk to anyone. This has been now months of their lives, you know. So from the perspective of the juror, I guess you can understand that, though it isn't fair, and that's not how this is supposed to work. Most of the jurors left court yesterday, did not talk to the media. A few local media outlets were able to get some interviews. WSB TV Channel 2 did speak with one of the jurors who said it did take a lot of compromise on both sides. There was a point when we didn't think we were going to get to guilt or innocence. But he also talked about how the jurors were able to look at the evidence, how they were able to get in the car, handle the gun, how they took turns coming up with that. How much of a part do you think that played? And do you agree that they should have been able to go back to the scene of the crime, essentially, and handle the gun?
I think throughout this trial, I think there was a feeling amongst the community, at least here in New York, that was watching this case, that some of the evidence and some of the law was a bit loosey-goosey when it came to the judge, whether it be that the jury was allowed to see 50 guns or however many guns that he possessed as somehow indication of his intent to kill, which to me was incredibly troubling and prejudicial in regards to the defense. But the minute you start to allow jurors to take it into their own hands to kind of create the evidence that they're looking for, you start to question, well, none of them are the size of Tex McIver. If they didn't have the evidence presented to them by the prosecution, remember, it's the prosecution's burden to prove this case beyond a reasonable doubt. It's not the defense to disprove it, and it's certainly not the juror's role to participate in the evidence fact-finding. And so I think there's a question as to whether or not this went far afield of what should have come in.
Yeah, I mean, one of the jurors told the local TV station, you know, and we had a few gun experts in the pool of jurors, so that helped explain the gun stuff, too. That's not their job, right? They're supposed to go off what they're told in this case.
Absolutely. And look, that can be a discussion, a potential issue for appeal, because one of the things the judge is always supposed to say is any expertise you have must be completely separated from the evidence you're viewing in this case. And so that's another incredibly troubling thing. I know that there were some jurors that were upset that the prosecutor didn't make out the murder and felt that the prosecutor should have worked harder to get to that top count.
Yeah, I mean, one of the jurors said that the deciding factor for her was the finger on the trigger after she got to hold the gun inside the car.
Right.
So, you know. But
I think one of the things, though, also that's disconcerting when we talk about a compromise, felony murder is the same sentence as murder. So when a juror's viewing that as a compromise, they don't realize that it's not really a compromise. They're actually sentencing an individual to life with potentially not realizing it. And so that's something that they shouldn't know, and it's right for them not to know. But now, as we look back at it, it really wasn't the compromise that they thought.
Well, this morning, earlier on Law&Crime Network, Jesse Weber did a really interesting interview with Bill Crane. He was a good friend of Tex McIver. At one point, Tex hired him as a spokesperson to talk to the media after the shooting happened in 2016. Bill Crane was one of the witnesses in this case, and as I said earlier this morning, our Jesse Weber spoke to him. So let's go ahead and replay that interview. Welcome back. I'm Stacey Delikat. We have just been watching Jesse Weber's interview with Bill Crane, a longtime friend of Tex McIver, and also someone who acted as his spokesperson initially after the death of Tex's wife, Diane, in 2016. Bill Crane, also a witness in this case. I'm in studio now with Law&Crime trial analyst Julie Rendelman. We heard Bill Crane say he, too, was shocked by this verdict. He believed that this was an accident and that Tex did not intend to shoot Diane back in 2016. And we have been talking about all afternoon how surprising this verdict was to so many people, because the prosecution was arguing for murder, that he intentionally killed his wife, that he did it for financial reasons, that he did it to get his hands on their assets because they had kept assets separate. But the jury acquitted McIver on that count and instead convicted on felony murder. And felony murder, right, as we're talking about, is like a different crime altogether.
Right. It's and it's peculiar in this state. In most states, when we're talking about felony murder, we're talking about a perfect example would be an individual goes into a bodega to commit a robbery, and the person who he is robbing has a heart attack and dies. That is the typical thing we think about when we think about felony murder, when the felony is a robbery, a rape, something separate from the death. This case is unusual because the underlying felony is the assault on the victim. And so most states don't allow that type of felony murder. This is not one of those states. So Atlanta or Georgia is an exception. And so that seems to be why the court could charge the jury and why the jury could come back with a guilty verdict.
Yeah, which some jurors admitted was a compromise after 5 long days of deliberations. Well, we know the felony murder charge carries a sentence of life in prison with a possibility of parole after 30 years. The judge did not yet set the date for the sentencing hearing, but that is still to come. And we know also that Tex McIver's team said they will appeal and are probably already starting to prepare that appeal. So this story is not totally over yet. In the meantime, we're going to take a quick break, but before we do, I want to let you know that on Law&Crime.com you can watch live streaming testimony from the trial against David Copperfield happening in a Las Vegas courtroom right now. In fact, Copperfield is on the stand, so be sure to check that out on Law&Crime.com. In the meantime, we're going to take a quick break, and we'll be right back with much more. Welcome back to Law and Crime Live. I'm Stacey Delikat here in studio with Julie Rendelman, Law and Crime trial analyst. Right now, our big trial today, that the murder trial against Shawn Grate out of Ohio. Shawn Grate, a suspected serial killer who was charged in the gruesome deaths of 2 women and charged with kidnapping and raping a third. In fact, he faces 23 felony charges, including 4 counts of aggravated murder, 4 counts of kidnapping, 2 counts of gross abuse of a corpse, 4 counts of burglary, tampering with evidence. The list goes on and on. In fact, Grate confessed to killing 5 women, though he's only on trial for 2 of those murders in this case. Yesterday, we heard opening arguments from the prosecution, and our own Aaron Keller has much more on that.
The trial of a suspected serial killer, 41-year-old Shawn Grate, is underway in Ashland, Ohio. Grate is accused of kidnapping and sexually assaulting a woman, and he's been charged in connection with the murders of 2 other women in an abandoned house. Grate was arrested when that woman he was holding captive was able to call 911 while he was asleep.
What's the problem? I've been abducted. Who abducted you? Shawn Grate. Where's he at now? Asleep.
In an opening statement, prosecutor Christopher Tunnell made it clear this case was not a whodunit.
The evidence will show beyond a reasonable doubt that this defendant was found asleep and naked in bed in a house that a terrified naked woman escaped from after being repeatedly assaulted and raped by this defendant. 2 decomposing bodies were found inside, having been kidnapped and murdered by this defendant.
He also went into detail about the defendant's involvement in the murder of 2 women found inside that abandoned house.
Even as he gives multiple versions of his killing Elizabeth to Detective Major, and he admits to killing Elizabeth Griffith. What exactly happened to Elizabeth Griffith, we'll never know. It would seem that after Stacey bought the defendant a cup of coffee at BP, she gave him a ride back to his place on Covert Court. And once inside that house, she never left. Recall that officers in their initial sweep of the residence, after forcing their way into the basement, sensed something was terribly wrong downstairs from the smell. The stench of death was strong. And after Stacey was strangled, she was wrapped in a basement and taken down the basement steps.
The prosecutor summed up his opening statement by reiterating there is no doubt the defendant is guilty of these alleged heinous crimes.
The evidence will show this is not a whodunit case. The evidence will show that this defendant is guilty of all 23 counts as contained in the indictment all specifications there too, beyond a reasonable doubt.
The defense did not give an opening statement, at least not yet. Grate faces 23 counts, including aggravated murder and kidnapping. If convicted, he could face the death penalty. For the Law and Crime Network, this is Aaron Keller.
Well, that was a summary of yesterday's opening arguments from prosecutors in the murder and abduction case against Shawn Grate. This is a death penalty case, by the way, in the state of Ohio. Grate faces 23 counts, as I said earlier, 4 counts of aggravated murder, 4 counts of kidnapping, 2 counts of gross abuse of a corpse. Basically, September 2016, one of his victims, who is just known as Jane Doe in this case, was able to escape from this house of horrors, really, as prosecutors describe it. She was able to escape naked after being held hostage there for days, being violently raped. Call 911. When police arrived, they found 2 badly decomposing corpses in his house, the bodies of Elizabeth Griffith and Stacey Hicks. Julie Rendelman, law and crime trial analyst, my biggest question right off the bat is, why do you think defense attorneys didn't do an opening argument yesterday? They waived their opening argument.
And so it's not unusual. I think a lot of people think it is. It's not unusual for a defense attorney to choose not to open. Sometimes the reason they do that is they will wait until the end of the prosecutor's case and then give an opening at that time, because then they have a chance to have looked at all the evidence that came in and give an opening statement. Sometimes the reason they do that, especially in a death penalty case like this, is that they don't want to offend the jury. They're not sure what their defense is going to be, and so they don't want to put themselves in a box so that they're defined by whatever their opening is. I will say, and I think, and you can agree or disagree, is that I think it is off-putting to the jury because you want to hear from the defense even though you're not obligated, and they're not obligated to speak.
As someone, if you don't follow trials a lot, you might be surprised. Are they just throwing the towel in? They're not even going to give an opening? But I'm surprised at what you said. They might not even know their defense yet. I mean, you'd think they've been preparing for this for a long time.
Well, this is an exceptional situation because this is a death penalty case where I think that they're going to be more focused on the sentencing phase than they're focused on the actual evidence. I think the evidence so far is overwhelming of his guilt. And so I think they may be saving themselves for the sentencing phase. But yes, there are cases where the defense isn't sure if they're going self-defense, if they're going identification, and so they don't want to tie themselves to anything when they're opening, and they want to wait to see what the prosecution presents.
This is another case, it seems like a few of the cases we've been covering lately, where the accused takes matters into their own hands and begins talking and talking and talking to anyone who will listen. After Shawn's Grate arrest, he did multiple media interviews. In fact, at one point, a judge had to step in and essentially put a gag order on him and say that people at the jail had to monitor who he was talking to. He was not allowed to talk anymore. In the course of all of these interviews he did, he admitted to these murders as well as at least 3 others. So certainly the fact, and jurors presumably are not supposed to know about those interviews, but this must be a very hard case for the defense with all that's already out there.
Well, it's hard to have control over a client that doesn't want to be controlled, and it's certainly very unusual to have a judge do a gag order on the defendant. It's usually the prosecution, it's the defense or witnesses. It's rarely the defendant. Right. And one of the things that's unusual on top of it is that the things the defendant is saying when he's interviewed are quite peculiar. I think there were statements made that the victims that died had already been dead
because they were taking government assistance because of the checks. I mean, clearly this is someone who has some serious mental issues, and that, I think, will be a part of the defense's argument when they eventually get to their side. Or do you think that is not until the sentencing phase?
I'm guessing that it's going to wait for the sentencing phase. Although, if someone does have a mental illness or defect, it's not unusual to bring it out before the death penalty phase, because then you get the jury understanding better about who the individual is that committed these crimes. I mean, since there's no question that he's the person that did it, I don't think that there's, so far that what we see, then it might behoove them to start earlier, to start explaining what their defense is, if it is a mental health or defect.
Although in another one of the media interviews Grate did, he said, I know it was wrong. So
Right.
it will be hard for the defense to argue that he was insane and he didn't know he was doing anything wrong.
Oh yeah, and I think that again might explain why it is that they're not going down that route. And I hate saying it, but a lot of times they're not sure what the defense is. And I know we talk about this because you're like, they've been doing this for months, but we don't know exactly what the evidence is until it comes out. And so it does give them time to change some of their strategies based on the evidence that the jury is presented with.
Well, we do know one of the big pieces of evidence that the prosecution started with right out the gate is the 911 call. This was a 19-minute 911 call made by that Jane Doe who was able to escape, able to free herself. It sounded like she had been restrained to the bed but was able to get up, sneak out, call for help. We heard a little bit of that in the piece from Aaron, but let's go ahead and play some more right now. Well, that was another snippet from the 911 call made by the victim known as Jane Doe, who was held hostage and violently raped by Shawn Grate back in 2016. When officers arrived, we know that they found two badly decomposing corpses in this house that prosecutors are really painting as a house of horrors. And I know we do have some photos we're going to show as I discuss this more with Law and Crime trial analyst Julie Rendelman. This is going to be a tough case for jurors to listen to just because, just in listening this morning to one of the chief investigators talk about how badly decomposed the two women's bodies were. One was in a closet covered with clothes and old toys that had been duct taped shut. He describes maggots and the eggs of the maggots hatching. The other was in the basement, basically thrown out with the trash. I mean, it's really a disturbing set of details.
Sure, and I think that, as a prosecutor and as a defense attorney, you really have to prepare the jury for this, for the graphic nature of what they're going to hear, because as a defense attorney, you want to make sure that they can hear it objectively and not use sympathy to make a decision in regards to whether or not they find him guilty, and eventually whether or not, if we assume that there's going to be a sentencing phase, whether or not they put him to death. And I think in the prosecution also, in order to have the jury believe in them, you want also to make sure that the jury is making their decisions without the passion that's involved in that feeling of being overwhelmed when you see such incredibly graphic and upsetting photos.
Yeah, absolutely. And I think we will be seeing a lot of that over the course of at least the next few days and weeks. I believe this trial expected to go at least 4 weeks. Prosecutors did their opening arguments yesterday. We started to hear from witnesses yesterday. Just to update all of our viewers, right now there is a brief lunch break going on in the Ohio courtroom. We expect court to resume about 1:30 Eastern time, and as soon as we have a live feed from the courtroom, we will bring that to you. In the meantime, we want to go back and watch a little bit more from opening arguments yesterday. Welcome back. We've been replaying some of yesterday's opening arguments from the prosecutors in the gruesome murder case against Shawn Grate out of Ohio. That was just the beginning of opening arguments. I have Julie Rendelman, Law and Crime trial analyst, with me. We started to hear from prosecutors right there about how Shawn Grate basically lived in this abandoned house where they found the decomposing bodies, that he lived there. He had lived somewhere else before, but moved there because he wanted privacy, perhaps to keep these bodies and cover up his crimes. I think what is very interesting about this case, obviously, is that one of his victims survived, was able to call 911 as he slept, somehow get a cell phone, call 911, who swept in, rescued her naked, terrified, and found these two decomposing bodies. Media reports from the local media out in Ohio indicate that Jane Doe will take the stand in this trial. That should be some very compelling testimony, wouldn't you think?
Absolutely. And I was saying to you before when we were listening to the 911 call, it's surreal. If I was the 911 operator, I would almost question the credibility of the witness, because she literally is sitting there, pretty calm. By the way, I'm incredibly impressed with her ability to stay calm, focused, and quiet, so she makes sure she doesn't wake him. But the circumstances of which she's describing, of which she was tied up and she, set herself free, and that he's about to wake up, are absolutely riveting. And I think that the jury, if they hear from her, which I expect they will be incredibly overwhelmed with what she has to tell them, and the fact that she now knows how close she came to death, which she probably didn't realize at that time.
Right. I mean, you have to wonder if she knew about the other bodies, the terribly decomposing bodies of two other women. We know one of those bodies was in the basement, but one of them was in a closet in a room, although it was taped off and covered with clothing. We heard one of the investigative agents testifying this morning about the maggots, the flies that they found near the corpse. We are going to go play a little bit more of prosecutors' arguments. Then I know you have to leave us, Julie, but we'll be right back with a little bit more analysis after we listen to this. Welcome back. We've been listening to the prosecution's opening arguments in the murder trial against Shawn Grate. It is a death penalty case out of Ohio. He faces 23 counts, everything from aggravated murder to assault to assaulting a corpse. We know 2 decomposed bodies, the bodies of 2 women, were found in the house he was living in September 2016. And that happened after one of his victims, who had been raped and held hostage, was able to sneak away and call 911 to that location. Julie Rendelman, law and crime trial analyst. One thing a lot of people may be wondering is that, we've been saying on the bottom of our screen even that Grate confessed to killing 5 women in the course of media interviews and interviews after being arrested for the crime. He said, yeah, I killed these 2 women as well as these other 3. In fact, he had some very convoluted reasoning as to why he killed them, saying they were already dead in their heads. He just basically took their bodies. But some people are wondering, well, if he confessed to killing 5 women, why is he only on trial for killing 2 of those?
Well, because first of all, it seems to me that the only evidence they have right now is the 2 bodies that were inside of the home, as well as the living witness, and so they may not have the evidence they need to go forward. One of the conversations we had before is not only, not going forward with these additional 3 murders, but, but in terms of him, is there evidence potentially that he committed not just 5 murders, but potentially more? This is an adult individual who one would be surprised if, since we now have 2 corpses, one would not be surprised to find additional victims. And so sometimes, in order to avoid the death penalty, a defendant will come forward and not just give the names of the victims, but give where they can locate the victims in order to avoid that. I don't know what transpired with regard to the prosecution and the defense as to whether or not there were any of these negotiations that exist, but I certainly think that the defendant loves to talk and he loves to get the attention. So it wouldn't surprise me if he's going to say more. Whether it's true or not, who knows? But there's going to be more to hear from.
And the judge had to order him not to say any more, as we were talking about a little bit earlier. When he was in jail leading up to his trial, the judge basically issuing a gag order: stop talking to the press, stop talking. The jailers started monitoring who he could and could not talk to, and write to as well, because he also sent letters to a local news station there even.
Right, and I think that's a bigger issue. That issue regards just this trial, because you don't want to impact the jury that is sitting there. And so the more he talks, the more the jury potentially is going to be influenced, and he wants to have a fair and impartial jury. And the way he does that is potentially to keep the defendant's mouth shut, which is kind of ironic considering the defendant is the individual that's on trial in this case.
All right, Julie Rendelman, thank you so much for being with us. As always, we are going to take a quick break. When we come back, we're going to be live inside the courtroom as this trial continues after the lunch break. Stay with us.